5 seconds to go. Start. Subsequent to the dismissal of the second appeal, the appellants and the respondents compromised their dispute, and such compromise was reduced into writing. According to the written compromise, the appellants were entitled to retain half of the two-third share of the land in dispute, and the respondents were to retain the other half. The respondents admitted in their compromise deed that the appellants had taken possession of their share of land. When this compromise was presented before the division bench of the High Court of Punjab and Haryana in letters patent appeal which came to be registered, the division bench of the High Court disposed of the said letters patent appeal in terms of the said compromise petition. Leaving aside the other facts in the present case, we may state here that a specific defense taken by the respondents in their written statement was to the effect that the suit was barred by limitation in view of Article 58 of the Act because the suit having been filed after about 18 years of entering into the compromise by the parties in the High Court in the letters patent appeal must be filed within 3 years from the date of entering into the alleged compromise by the parties. Accordingly, the respondents alleged that the suit must be dismissed on the ground of limitation. We make it clear that since the only question involved in this appeal is relating to the question of limitation, we have not considered the other aspects of the matter in this judgment. After the parties had entered appearance and led evidence in support of their respective cases also on the point of limitation, the trial court held inter alia that the suit was barred by limitation in view of Article 58 of the Act as the cause of action arose in 1972. The High Court has not exercised the caution that was expected to while dealing with the judgment of acquittal by the trial court. High Court was not justified in interfering with the well-considered judgment of the trial court. The judgment of the High Court is set aside and that of the trial court is restored. The appellant is allowed to go in appeal to the higher court if he is not satisfied with the judgment of this court. Leave is granted to pursue the matter in any court for final decision. Sir, thank you for giving me the opportunity to speak on the company's amendment bill. Sir, this house and the other house passed the Companies Amendment Act 2013 after an exercise of more than a decade. The Companies Act 1956 was replaced by the Companies Act 2013 after a prolonged discussion, deliberations with the industry, chambers, and all the stakeholders. After several recommendations by the Standing Committee, it went twice to the Standing Committee. Only in 2013, the 1956 Act was replaced by Companies Act 2013. Now, the Act was notified only partially in 2013 and from 1st April 2014, the Act was implemented. Within a period of 6 months, the government has come out with several amendments to the Act and there are nearly 14 sections which have been amended. I do not see any reason for amendment of some of the provisions like removing the threshold limit for minimum capital requirement for private companies and public companies. The previous act clearly says that the private companies should have a minimum capital of 1 lakh and the public companies should have a minimum capital of 5 lakh. This was a provision introduced to curb the shell companies and to put restrictions while incorporating the companies. This has been removed, and then there is no capital requirement envisaged in the present amendment for incorporating a company. Then the next amendment is not making the common seal mandatory. The common seal is a seal which authenticates all documents of a company, and that is a seal which is required to be authenticated, and that has been made optional. I do not see any reason for this change. Then I welcome that section 76A has been added to protect the depositors and to make the offence a cognizable offence under section 447. We have to protect the depositors. Of course, the original section, which is section 76, has the provision to protect them, but now more transparency has been brought in. I welcome it as far as section 188 is concerned, where an agreement to be filed. In certain cases, special resolution was necessary, which was very important. That has been removed. If these provisions can be passed with an ordinary resolution, I feel that this amendment is not necessary. Stop.